All rise. The Court of Appeals, Division 1 is now in session.
Thank you. Please be seated. Good morning. This is the time set for oral argument in our cause number CV140505, Fees versus Fees. Counsel, we are recording today's proceedings, so when you step to the podium, please identify yourself and the client you represent. Each side will have 20 minutes for argument, and Mr. Collins, as the appellant, you're responsible for watching the clock and reserving any time for rebuttal that you might desire. We've read the briefs and we've conferenced the case prior to argument. So with those preliminaries out of the way, Mr. Collins, you may proceed.
Thank you. For the record, Your Honor, I'm C. Robert Collins. I represent Wayland Fees, who is the appellant in this court, the defendant in the court below. Your Honor, this case is almost a family law case, even though it's in the civil arena. It involves two summary judgments that were granted. One was ignored and one was granted.
Well, I thought the first one was denied.
I'm sorry. You're correct.
Because there were two affidavits that were submitted.
Your Honor's correct.
He's always
I've been
correct.
up most of the night because of a family problem, so you'll have to pardon me.
No.
Anyway, the first one was denied. You're correct. Second one was granted. Between the first and second summary judgment, discovery was done, depositions were taken, and in fact, more disputed facts occurred. The really pivotal point here.
The pivotal point is, it's an interesting point. It's whether the Superior Court should have looked back to basically the notary affidavit in connection with the first round of briefing and found it.
I apologize, Your Honor. I can't hear, and I left my hearing aids at home.
Oh, okay. I'll talk loudly. Is that better? All right.
You do a good job, Your Honor.
Isn't the key issue whether the Superior Court in the second round of summary judgment briefing should have looked back at the notary's affidavit?
That's our contention. Our contention is that probably not the first round as Mr. Fees is representing himself, but we do believe that when the Rule 60C motion was filed and all of that evidence gathered, that the court should have then denied or reversed itself on the second summary judgment. I have to tell you, Your Honor, I had a case exactly like this 2 weeks ago. Except I was in my colleague's place. We had issued some requests for admissions of fact. In that case, there had never been a summary judgment. 7 months had passed. We showed up in court using and in my trial case the other day, only half the requests were denied, the other half were ignored, assuming then, therefore, they're admitted. And we showed up in court to argue it, and the trial judge said, give him 10 more days to answer the rest of them. Now, I'm not criticizing anyone except to point out that's what almost always happens at the trial level. As a result, I've often been very cautious in that when I send out requests to admit facts, I always send out a notice that those facts are admitted for failure to respond. And in fact, I do everything I can to give the other side the opportunity to answer. So I see that as a difficulty, Your Honor. I've cited all the rules and the philosophy of the law, let's say, and I know you've read them all because I've been in front of all of you before, and I know that's the case. If you have questions, perhaps I could address them because the court clearly has the crux of what the arguments are.
You want to save the rest of your time for rebuttal then?
I'll save the rest of my time. Thank you.
All righty. And Mr. Elstock?
For the record, Barry Elstock for appellee Darlene Fees, mother. May it please the court. Appellants have made this appeal about terms like justice, form over substance, trickery against a non-represented party by a represented party. While justice is extremely important, we believe that when viewing the trial court proceedings objectively, that justice was served. Moreover, this appeal is really about the judicial process, the Arizona Rules of Civil Procedure, which apply equally to represented and unrepresented parties alike. If the court would like, I believe that our brief.
I was going to say, answer Judge Downey's question, that here, at least when the court was looking at the second motion for summary judgment, both Mr. Fee's affidavit and Ms. Bunfield's affidavit were still sitting there unchallenged when the court made that determination. And it hadn't been that long a period of time before that motion for partial summary judgment had been denied.
That's right, Your Honor, but in the interim, there was discovery that had been undertaken. There were 2 depositions, both of Mr. Fees and Ms. Bunfield. There were requests for admissions that were not answered, deemed admitted by the rule. There were non-uniform interrogatories that were not answered. And there was just the general motion practice that had preceded the second motion for summary judgment, which was a partial motion for summary judgment.
Maybe I missed it. Did Ms. Bunfield contradict herself from her earlier affidavit?
Her deposition that was conducted created some inconsistencies, and the theory of our case was that because the requests for admissions went unanswered and so they were admitted, along with some of the admissions that were made in Mr. Fees' deposition, that Ms. Bunfield's earlier affidavit and her deposition wasn't necessary for the motion for summary judgment in terms of proving our case.
Had the notary's affidavit been resubmitted in connection with the second motion for summary judgment, don't you agree that would create a genuine issue of material fact?
Well, Your Honor, I believe it would have to be submitted along with her deposition transcript. But I do not believe that her deposition would contradict, in terms of a full record, our client's sworn statements as well as Mr. Fee's statements in the deposition and his request for admissions that went unanswered.
So you don't think that would have created a genuine issue of material fact
I
had
don't
it been
believe it-
carried forward?
Excuse me. I don't believe it would have created a genuine issue. I believe that there could have been an assertion that there's a contested fact. I don't think it would have prevented the judgment in our favor on the motion.
Okay, well, let's assume for the sake of argument we think it might have. I'm very familiar with Tilley versus Delsey because I wrote it, and I see some distinctions between this case and Tilley. In Tilley, the discovery responses were not part of the record before the court, so the court couldn't go back and look to see if there was a genuine issue of material fact. But we've got the case law that says it's not enough that someone doesn't respond to a motion for summary judgment. The court still has an affirmative duty to determine whether summary judgment is warranted. So what does that mean? And in this case, which is not a hugely voluminous case like is discussed in Mast and some of the others, it didn't require the court much to look at this affidavit from the prior proceeding, which presumably was part of the reason it denied summary judgment in the past. So where's the boundary between what the court has to look at in the record and when it can just rely on what's been submitted?
Well, I think the court has a duty under the rule, under the case law, to look at the entire record that's been submitted to it. And so the previous affidavits that were submitted on the first motion for summary judgment were certainly part of the court's record. The depositions outside of what was pulled for the exhibits to our second motion for summary judgment weren't part of the record. They weren't submitted. And so having no response to the motion for summary judgment or the request for admissions, it created the record that we provided, which was favorable to the case, and it was not opposed. I suppose had a response been filed that the defendant could have looked for statements in his deposition, perhaps in the third-party deposition, or could have filed a new affidavit. That wasn't done, and that was not the only time that there was a failure to respond to a filing. There was a failure to respond to the amended complaint, as well as this motion for summary judgment. Part of what we're trying to show the court is that this wasn't an isolated incident, that it wasn't an injustice, that this is how the case really proceeded, and became as protracted as it was. But, Your Honor, I agree that the court has a duty to look at the record. The record before it did include the affidavit, but the affidavit, we believe, was countered by Mr. Fees' statements in the deposition, as well as his request for admissions that went admitted.
But even if we agree with you there with respect to the request for admissions, there was still Ms. Bunfield's affidavit And I think I heard you say that you did not submit her portions of the depositions to the court.
That's correct.
So it was still her affidavit was still sitting there
Presumably in the court file, Your Honor.
in the court file. Yeah, okay.
Anything else you wanted to add? Or?
No, Your Honor.
No? Thank you.
Thank you.
Any rebuttal, Mr. Collins?
I think this is the first time in my many years in front of the Court of Appeals where I've got a little time. Your Honor, some of the comments counsel makes and some of the concerns of the court are interesting. Counsel says, if I understand the argument correctly, that the failure of Mr. Fees to answer the request for admissions trumps his affidavit in which he basically disputes all of the positions of his mother. It trumps the record that was before the court already, and it trumps the Rule 60C motion. Now, I harp a little bit on the Rule 60C because that gathered all of the information that was in the record, and I understand the purpose of Rule 56. Rule 56 is designed to help a trial judge receive all of the information so the trial judge doesn't have to go hunt it. I understand that. And that didn't happen in this case. Mr. Fees had a fool for a client because he represented himself. And unfortunately that happens. But then you've got the rules that say no specific form of pleading is required. I'm a lawyer, and I've been doing this 45 years.
I was going to say, Mr. Collins, I think the court recognized by determining that certain of Mr. Fees' pleadings were really raising a motion for summary judgment or trying to respond in some fashion, but that he still, and in fact, when Ms. Fees filed a default, when he didn't answer the amended complaint, the court said, I'm not going to deal with it, and then gave him some time to file an answer. So I think the court was trying to make it work. But here we are.
You have to keep in mind, Your Honor, that 2 notices of default were filed, not 1. The first notice of default, he wasn't in default because he had answered. But it was filed anyway, and so, pardon the expression, he went berserk on responding to that. His pleadings don't make any sense to me either, Your Honor. But then when the admissions are due, a second notice of default is filed, which I guess you could say pushed Mr. Fee's buttons, and he got diverted onto the second claim of default. Now, frankly, I understand the frustration of the trial judge in this case, but it seems to me, forgetting everything that happened with Mr. Fees representing himself, it seems to me that at the Rule 60C level, the information was brought before the court in a proper fashion, fitting the rules. Now, I believe, and I could be wrong, the rules of ethics require lawyers to tell courts not only if there's a case against them, and the rule's very specific on that, 3.3, ER 3.3, but to also tell the court if there are disputed facts. Now, if the plaintiff in this case had have said...
That's a good argument, honestly. I don't think that's a good argument, and I think it dilutes your otherwise good arguments. To try to say that somehow the plaintiff's lawyer had a duty to essentially come forward and raise facts. I mean, I don't know that there's any support in the law or the ethics rule, and I think you've got better arguments than that.
Well, I think there are better arguments than that. I raise that, though, because I think it's an important consideration, perhaps. Not a great argument, but I think it's something the court has to look at. First off, I don't think the request for admission should have ever been sent because they'd had depositions, they had affidavits. Counsel says he thinks is it Bunfill? My client always gets after me for pronouncing that wrong. But that affidavit, they wanted to take her deposition, never did. But that affidavit clearly says, I explained to the plaintiff the meaning of this deed. She was emphatic that she did not want a deed effective upon death. And she was emphatic that she understood that this deed was not what she later claimed in the litigation it was. Now, that seems to me, if we're talking justice, to be an important point that ought to be considered. It would be a nightmare to try this case, Your Honor, without lawyers involved. But as the court pointed out, we are where we are, I guess, today.
Well, let me ask you this, Mr. Collins, and since this is truly a family affair, have the parties attempted to arbitrate or mediate their differences? Because at least according to Mr. Fees' affidavit and Ms. Bunfill's affidavit, Ms. Fees was trying to avoid having a difficult relationship with Waylon that may have occurred with the other sons. And obviously, the longer we get into this, and if we agree with you and send this back, it just continues to churn the relationship that probably needs to be repaired in some fashion.
Well, counsel and I have actually discussed this, and we've discussed settlement repeatedly.
Okay.
Unfortunately, at least to Mr. Fees'
I just asked the question. I don't need to.
I know we don't get into those, but I guess the point is I agree with the court that this would be a better resolution, would be the parties to sit down and solve it and try to repair this relationship. Unfortunately, sometimes people get hurt to the point where that's not possible, as the court's aware. Okay. In fact, the court's a great mediator, so you're aware of those things. There was an interesting point, though, that Judge Downey brought up, and that is that even if the facts are not disputed, the person still has to be entitled to judgment as a matter of law under Rule 56. And the defense or the reason that the plaintiff in this case says set the deed aside was, and I quote, I didn't understand what I signed. That's her defense for it. And she says, since I didn't understand it, you should set it aside. Or in this case, didn't set it aside, they reformed it and said that it's a deed only upon death. Now, we cited the court several cases, the Gutierrez case being one of them, that says that defense is not appropriate, nor does it set aside that deed as a matter of law. And so, even though that may be her position, which we don't think is correct because of the Boonville affidavit and the other things that occurred in this case, she wasn't entitled to summary judgment as a matter of law, at least according to the case law. Counsel talks about form over substance, and I guess the point that you raise is, does counsel have a duty to inform the court of prior disputed facts? I'm going to have to let you decide that. That's why you guys get the big bucks, as they say. But if truly Rule 1, and I'm probably the only lawyer that's ever cited Rule 1 that I know of, but if Rule 1 is truly the focus of what we do in the court system, then we seek and look for justice. And you have to ask yourself in this case, just looking at the attorney's fees alone, $53,000 in attorney's fees plus the loss of a home because this man missed answering requests for admissions. I just don't think that's appropriate. If the court has any other questions, I'll address them, but
No, we don't.
thank you, Your Honor.
Thank you both for your presentations. We will take this matter under advisement and issue a ruling in due course. At this time, the court stands adjourned. Thank you.